San Antonio attorney Alan Tysinger answering the question, can I settle my Texas workers' compensation claim? The answer to that is pretty much no, but there's a little bit of nuance. Let me explain. In Texas, if you get hurt on the job and your employer has a workers' compensation insurance policy, you file a claim with that policy for monetary and medical benefits. So the insurance company may have to pay income benefits for time lost from work. They may have to pay income benefits for permanent damage to your body from the injury. I'll explain that in other videos. And they're also liable for medical costs. That would include medical care, treatment, emergency room bills, diagnostic imaging, physical therapy, medications, potentially travel reimbursement, surgeries. All those things would be covered for the medical benefits in the case. And under the law, you cannot settle the claim and rule out future medical costs from the claim. That's excluded from the law, not legal. So no court would approve that. The Workers' Compensation Office would not approve that. Cannot be done. So what can be done in terms of settlement? Well, there are a couple of things that can be done in terms of a settlement. Number one is if the parties have a dispute over future income benefits that may be owed, then typically that'll come in for what we call supplemental income benefits, more severe injuries that have a duration of up to about 7.5 years. There is a procedure for entering into a settlement that will pretty much confirm the medical diagnoses and the fact of future medical care being available. And then the settlement will provide for the schedule at which and the limitations upon the future income benefits to be paid. So in other words, a person might have entitlement potentially under the law for benefits to last another 2.5 years, but the parties will agree that rather than the benefits extending for the remaining 2.5 years, the benefits will only last for another 1 year. And those benefits would still not be paid out in a lump sum. They would be paid out on the schedule that is outlined in the law, so they would be paid when they are payable according to the legal guidelines. But the employee would be relieved of the responsibility to actually file the paperwork to go and get those. They would sort of be baked in to the approved settlement. Those settlements are rarely approved. Not really sure why. It's just that some people have gone back in and complained that they didn't understand what they were doing and they wanted to get the rest of the benefits. And of course, that can't be done once you've signed off on something like that. So those sorts of things are typically not approved, and there's not much advantage to them anyway unless you are already in a situation where benefits have been denied. You're probably not going to win. At best, the winning is uncertain, and you want to have some certainty and clarity over what remaining benefits you may be able to get. But even in those cases, you can't settle the case, take a lump sum of cash, and exclude right to future medical care. Some people look at things and think they're a settlement when they're really not. So one of the things you can do is if you get an impairment rating percentage for the permanent damage to your body, normally that's going to be paid out over time. So you receive an impairment rating percentage. That percentage entitles you to 3 weeks of benefits for every percentage assigned. And so under that rating, let's say you get a 5%, you may get an additional 15 weeks of benefits. If you're already back to work for at least 3 months, you can apply to get those in a lump sum. Now that's not really a settlement, that's just getting what you would have gotten anyway, but getting it early. So that's something that you can do. The other thing that people might think of as a settlement is when you have a dispute over certain medical conditions. Let's say the insurance company says, we don't think your lumbar herniated disc is from this accident, so we don't want to pay for it. We don't want to pay for medical care. We don't want to pay for anything related to that. Well, you can sort of horse trade when it comes to those things. In other words, if the lumbar herniated disc is already determined to be part of the injury, you can't wipe that out and exclude future medical care for it. But if it's in dispute and there's also a legitimate dispute about monetary benefits, let's say at the same time the insurance company is disputing your entitlement to medical care for a herniated disc in your back, they're also disputing whether or not you were disabled for the last year and whether or not you're entitled to monetary benefits for that. So in that situation, you could go to the insurance company and say, look, if you'll pay me for the entire time I've been out, I will agree that that herniated disc is not from this accident. You don't have to worry about paying for the surgery. That is legal. That can be done. And those are the dimensions of potential settlement in a Texas workers' compensation claim.